Judge, as the court is aware, Mr. Suitt was convicted by a jury of a third and a fourth degree offense. If we were dealing with virtually any other third and fourth degree offense, we'd be talking about a situation where, because of his lack of prior history, he enjoyed the presumption of non-incarceration. Due to the conviction, Judge, for the official misconduct, as the court is aware, has been hashed out numerous times, both at adjourned sentencing dates as well as shortly after trial on motions filed by the defense for reconsideration, as well as judgment notwithstanding the verdict. That being said, Judge, there is an avenue of relief to Mr. Suitt statutorily in which the court could impose a sentence which does not require the minimum mandatory sentence of 2 years in state prison on a third degree official misconduct. Namely, Judge, NJSA 2C 43-6.5C2, which provides, if the court finds by clear and convincing evidence that extraordinary circumstances exist, such that an imposition of a mandatory minimum term of imprisonment would be a serious injustice which overrides the need to deter such conduct in others, the court may waive or reduce the mandatory minimum term of imprisonment required. Further, in making any such finding, the court must state with specificity its reasons for waiving or reducing the mandatory minimum sentence that would otherwise apply. And Judge, there's some cases that are cited in my brief that discuss that a little bit further. I would submit to the court, Judge, as I did in writing, that there are a number of mitigating factors that apply in this particular case. I cited 2 mitigating factors: 6, 7, 8, 9, 10, and 11. Judge, and I did cite to one aggravating factor, which is virtually in every case, which would be aggravating factor number 9. I would ask the court not to find any other aggravating factors, as I don't believe or would submit that any of the remaining aggravating factors apply to Mr. Suitt or the nature of this case. Judge, mitigating factor number 6 talks about compensating or the ability to compensate the victim of a crime. Judge, here, as going through the pre-sentence report, it appears as though there's no victim impact statement. Although at trial, Mr. Suitt was convicted of taking money from the victim in this matter. He's certainly willing and able to reimburse or pay back the victim the amount of money that was taken. Additionally, Judge, he's willing to perform any community service or any other conditions of probation should the court be inclined to go along with the defendant's argument in lieu of a jail sentence. Judge, mitigating factor number 7, I believe the state in their brief also said that mitigating factor number 7 applied, which, as the court's aware, there's no prior record, and here certainly as a Jersey City police officer up to the time, although a dismissal is noted in his pre-sentence report, there are no convictions and no record of any kind for Mr. Suitt. Mitigating factor number 8 applies where the defendant's conduct was the result of circumstances unlikely to recur. Judge, in this case, as the court's very well aware, my client was convicted of taking money at a motor vehicle stop as a police officer. He's lost that employment, Judge. Certainly, there is no ability for this to happen again, as there's no ability for Mr. Suitt to be in a position of any position of authority or with a city, a state, a municipality where the incident could recur. Mitigating factor number 9, Judge, the character and attitude of the defendant indicate that he is unlikely to commit another offense. Judge, my client has maintained his innocence throughout this. He still maintains his innocence. That shouldn't be a disqualifying factor. As to mitigating factor number 9, I would submit to the court. But Judge, what I would ask the court to consider is, upon conviction in this matter, Your Honor released my client, and he remained out of custody for, I think, we're over a year at this point, Judge, almost 17 months. We've had a number of court dates, as the court's aware. We've asked for adjournments for the defendant. They've been granted. Each and every time that we've appeared, Judge, both, I think we did appear a couple times virtually, but certainly here in person, my client has been here. He's been prompt. He's had no issues outside of the courthouse or outside with pretrial monitoring or anything of that nature. So, Judge, I would submit that certainly his character and attitude indicate that he's unlikely to commit another offense. Judge, mitigating factor number 10 about probation, or that probation would be appropriate, or he would be a likely candidate to succeed at probation. Judge, that speaks for itself based upon the statements that I've already relayed to the court. And then, Judge, I cited to mitigating factor number 11. As is referenced in the pre-sentence report, I believe has been stated on the record, at times my client is a business owner here in Jersey City of Winging It Restaurant. Judge, he's responsible for that restaurant. He does have a partner, as Ms. Guyhammer stated in her brief. But Judge, he's at least half responsible for that business, for its employees, for its success, for its continual ability to have, one, serve the community with food, but more importantly, Judge, have employees and have them continue to get paid and continue to succeed and that business to grow. Certainly putting him in prison would entail a hardship not only to himself, to those employees, and then, Judge, the obvious people that and anyone's family or whatever is applicable in every case. Judge, those were the statutory mitigating factors that I would cite to, and I believe the court should find. In this particular case, Judge, that's not where it ends, and that's what I referenced in my brief. As Your Honor stated, you have a number of letters. Judge, those letters, page 9 of the pre-sentence report, speak to Mr. Suitt's upbringing and difficulties that he's had getting to the point that he became a Jersey City police officer. Judge, he was in a number of foster homes. He was abused, as is referenced, both physically, mentally. In each of those placements, Judge, he became homeless at a certain point in time. He bounced around the foster home system. Judge, we stand here with somebody that should be a success story. Again, he was found guilty of something he maintains his innocence to, but he was found guilty. This should be a different proceeding for somebody like Mr. Suitt. He should be in a situation where he's speaking to the court about the successes in his life and why he is a police officer and how he overcame what's referenced in both those letters as well as the pre-sentence report and got to the place that he was. Judge, obviously the easier route would be to go how, unfortunately, a lot of the individuals that we deal with, both on this side of the table as well as Your Honor, in our criminal courtrooms, where you go down a different path, Judge, whether that be on the street selling drugs or whether that be committing other types of crimes. Mr. Suitt was the opposite of that, Judge. He overcame that. He got through college. He became a police officer. He's a successful business owner. Again, it should be a success story. But Judge, for all of those reasons, as well as the remainder, and I went through a lot of my brief, but along with the remainder of the arguments in my submission, as well as, Judge, quite frankly, what's referenced in the pre-sentence report about Mr. Suitt, about the situation, about where everything stands, I would ask that the court find that 2C43 6.5C2 does apply in this particular case, that this is extraordinary circumstances, or there are extraordinary circumstances for this court to impose a probationary sentence. Because I'm not going to get into what conditions of probation we would ask for, other than to say, if the court agrees with our argument, the number of years are irrelevant, the conditions are irrelevant, Mr. Suitt will successfully complete them, and I can assure the court that neither Your Honor or any other court or judge sitting in the position that you're in will send Mr. Suitt back in front of them. Thank you.
In response to a statement that counsel made, there is no victim impact statement contained in the pre-sentence report because the victim was here himself to speak to Your Honor to talk about how the incident in which the crimes for which Mr. Suitt has been convicted have impacted his personal life. So at this time, the state will call Jermaine Palms.
Just like, good morning, sir. Could you place your name on that?
Jermaine Palms.
Go ahead.
Well, that night when it happened, you know, I didn't have 2 nickels, no money, and it affected my life. I lost custody of my 13-year-old daughter when she's 16. I lost my ex-fiance behind all this money. And the whole thing was, I borrowed the money. And when I went to the precinct, South District, the cops treated me like I was a peasant, like I wasn't a citizen. They shunned me away. They were like, oh, this, like nothing happened. So I had to go to the bigger people, internal affairs, this and this. And I told them from the door, I'll take a lie detector test. And they're still running around saying, oh, this man ain't take it, going to get people. Got a guy on Garden State TV, assassinating my character, talking about my jacket. Oh, that's years ago when I was younger. I haven't been in trouble in 12 years, not even a ticket, right? And it's just a shame that this man could sit here and say that he didn't take my money out of my wallet. And then I sees him, a mother go at the park, And I'm standing in the park, and he walks by, my friend, shaking my friend's hand, and I sees him, I said, you know what? Let me walk across the street. And I walk across the street, go by my car, and he just staring me down. And I said, you know what? I'm not gonna get in trouble. I said, I'm gonna make sure I'm here. Because you know what? Once he got convicted, I said, okay, as long as I get my money back. But you know what? If he did this to me, he's been doing it. And he deserves jail time. The same way anything I did in my life, and anything I did, I was responsible for it. I said, you know what? I'm not crying about it. I went to prison. I went to jail. I didn't cry about it. I accepted it. So he took my money, and I want to see him go to prison also. It set me back. I was sleeping in cars, everything. Because the same money that was loaned to me, I made sure I paid it back. So I don't like owing nobody nothing. I'm a standard guy. So just because I have a record or I did this and this doesn't mean that he didn't take my money. And he took my money out of my wallet. And he sits there, and even when he see me in the park, he could have came and said, you know what, I apologize, man, I was wrong, brother. And then to try to use a black thing, I'm black, he's black. You know, and no way that he should get a slap on the wrist when he took something to trial. He had the opportunity to cop out, to take probation, to take whatever. And he chose not, because he thinks he's bigger than the law. So he said, oh, I'll go to trial, I'll beat it. Now he's found guilty, now he's running around getting people, Bruce Austin, he didn't even know I know him. I know all these guys that he went to try to assassinate my character. But they didn't know that was me. And Your Honor, it just set me back. And I'm just getting back on track. It took me 3 years. 3 years. And I was stressed out, I lost weight, everything. Then I would see cops, I get paranoid, and how he disrespected me that day, even when I had alcohol in the car, this and this, he gave me no ticket, nothing. I was by a fire hydrant. And then I went to him, I said, excuse me, officer. I said, you think I should move this car? He said, how old are you? At the time I was like 44. I said, I'm 44. He said, you know how to drive, right? Disrespectful. He's a disrespectful man, and I don't see him go to prison. I don't want no probation, none of that. Same way with the prison, he deserves to go too. That's all I have to say.
Thank you.
Thank you for your response. Your Honor, I'm just going to briefly go through a short timeline for the court, because it's been a long time since the state has been able to address this matter on the record.
So is it okay if we sit?
Sure.
Okay.
It's okay. On February 14th, 2019, a Hudson County grand jury comprised of tax-paying residents of Hudson County heard evidence, including live testimony from the man who just spoke to the court. On that date, having heard the testimony and the law that was read to them by another assistant prosecutor, the grand jury found that there was probable cause to charge Denzel Suitt by way of indictment with official misconduct and theft by unlawful taking. And I point that out because in the face of allegations that this man has been unfairly targeted by my office or by members of the Jersey City Police Department who participated in the criminal investigation into what he did, we didn't even charge him. The grand jury charged Denzel Suitt. He wasn't charged by a complaint issued by Jersey City Police Department, nor was he charged by a complaint issued by my office. Prior to his personal assistance in selecting a jury, a diverse jury, of members of this community, Mr. Suitt, like any other defendant that appears in this county, was given a plea offer. He was offered plead guilty to theft by unlawful taking, forfeit your job as a public employee based on what the proofs show, and you can have pretrial intervention and avoid incarceration. Because as we all know, the sentencing law, as it pertains to official misconduct, is serious. It's always been serious, and it has never changed. Mr. Suitt exercised his constitutional right. It is absolutely his unassailable constitutional right to maintain his innocence and go to trial. And that's what he did. And he was found guilty by members of the jury who convicted him in a unanimous verdict after reviewing all of the testimony, all of the physical exhibits, following Your Honor's instructions at the end of trial and the beginning of trial, where they were told to weigh the credibility of each and every witness. That means each and every witness that I called to the stand, to determine credibility or lack of credibility, to assess the evidence or lack of evidence that was presented to them, to determine what was inconsistent, if anything, in the proofs that were submitted to them. I submit to this court that they did that because they returned a unanimous verdict of guilty. It's been exactly 1 year, 4 months, 3 days, or 489 days since Denzel Suitt was convicted by his peers of committing the crimes against Jermaine Palms and against his police department, against the oath he took. NJSA 2C43 6.5 is clear. It requires that a person like Mr. Suitt, who serves as a public employee and is convicted of a crime which involves or touches upon his or her employment, shall be sentenced to a mandatory minimum term of imprisonment without eligibility for parole. There's only one legally recognized exception to that statute, as Mr. Hirschorn pointed out. A defendant has to present, and the court must find the existence of truly extraordinary and unanticipated circumstances such that any imposition of incarceration would amount to a serious injustice, so great that it would override the cornerstone of our criminal justice system, deterrence, specific and general deterrence. While I agree with Mr. Hirschorn that deterrence, otherwise known as aggravating factor 9, is certainly present in every criminal case, it is no more critical than its presence is in this case, where a police officer has been convicted by his own community of committing crimes of official misconduct and theft against a person also of his own community. The public trust has been violated, an oath of office has been violated, and the legislature has created sentencing law that achieves the deterrence that I'm talking about through incarceration, not rehabilitation. That is the law as it existed on the date of the offenses that he was convicted of having committed. It was the law at the time that a plea offer was tendered to him, which would have avoided incarceration. It was the law throughout the trial. It was the law on the day that he was convicted. It has been the law, and it has not changed. There are only 2 published decisions to date that have found serious injustice standard has been that was satisfied. Both highlight that a defendant's personal circumstances must be so extraordinarily unique that they eliminate the need for general deterrence. The first case is Jarvis, which we're all familiar with, where the Supreme Court affirmed that a non-custodial sentence imposed on a psychotic woman with severe intellectual disabilities who had accidentally killed her newborn baby by dropping him. The court held that that defendant was so mentally unfit that she couldn't appreciate the wrongfulness of her conduct. She would be mentally unable to understand what she had done or benefit from any sort of deterrence. The condition and the facts of her case were characterized as so idiosyncratic that any incarceration would have been unlikely to serve as a general deterrence to others to not engage in parental neglect or neglect of child care responsibilities. But she couldn't, further, that defendant was so ill that she couldn't endure life as an incarcerated human being because her physical and mental condition subjected her to conditions that were found to be so inhumane because of her, that probation was given. She couldn't survive prison. Certainly, that's not what's being submitted to this court. The second case, a 5-year non-custodial probation and house arrest for 2 second-degree crimes was given where a defendant was suffering and bedridden with terminal HIV. Nobody here is offering to this court that this defendant is suffering from a terminal illness. Those are the only 2 cases in this state where the mandatory minimum waiver has been upheld. In considering Mr. Suitt's undeniably tragic childhood, we have to look to see whether or not there's clear and convincing evidence of mitigating factors that are not only extraordinary, but unanticipated by this defendant. Further, that the quality, not the quantity of those extraordinary factors, they have to cumulatively outweigh any aggravating factors to such a degree that the objective of the criminal code, which, as I already stated, is deterrence, would not be achieved. It cannot be argued that this man's horrendous childhood, which he admittedly pulled himself up out of, makes him any different from any other criminal defendant who comes before your honor and tells you about an equally, or not even equally, another tragic upbringing. He is not different than any other defendant who has committed a crime and came from a horrendous background. This legislature is clear. If you violate your oath of office and you act while in performance of your duties and you prey upon members of the community, you are going to jail if you are convicted. That's the law. It is harsh. Case law says it's harsh. I can't do anything about that. Your Honor can't do anything about that. He has not met the standard. Here, Mr. Suitt contends that he is unique because of his upbringing. He spent his childhood bouncing around, as Mr. Hirschorn said, the foster care system. And I personally cannot imagine the horrors that he must have endured. He was smart enough and fortunate enough to be able to pull himself out of that, albeit he was homeless for a short period of time, to gather the funds needed to take the civil service exam so that he could try his hand at being a Jersey City police officer. And this is where I submit to the court he hit a fork in the road. He could either become the hero that he should have had, or he could take the other path, which was to continue the path of victimizing, how he was victimized. He made a conscious decision to take the path to victimize others. He was a cop by day and a business owner, and by night, he was committing crimes. He committed a crime, and the jury found him guilty. He made a choice when he was faced with that fork in the road. Defendant argues for the application of mitigating factor 6, which states he will compensate the victim of his conduct for damage or injury that he sustained, or will participate in a program of community service. There is nothing, I submit, in the record to support the application of mitigating factor 6. The record, in fact, supports the exact opposite. Posed to the court by the defendant as simply making restitution will eliminate any pain caused by the crime and any loss of money. It fails to take into account that compensation in a case like this is not always going to be financial. You heard from Mr. Palms the indignities that that man suffered and his brother suffered, and we heard about it throughout the course of the trial. You can't make up for that. Those are indignities that financially set him back and clearly scarred him. He's branded with the memory of being treated like trash that entire night. In committing the theft that he did in the Greenville section of Jersey City against a man who he himself says didn't have 2 nickels to rub together, this former police officer reinforced Mr. Palms and his brother, who grew up in Greenville, reinforced their belief, as well as other community members in Greenville, that police, regardless of their own color or gender, can't be trusted to police communities of color. I said it in my trial, and I'll say it now. That is one of the most neglected areas of Jersey City. The CCTV camera on Bayside Terrace had been non-functional for years. Mr. Palms didn't know it wasn't working, but he knew it wasn't working, and it wasn't working maybe because it was in Greenville, and that's a highly ignored area. course, Mr. Palms is entitled to restitution from the defendant. But financial restitution, nor any term of community service as part of probation, has the capacity to erase the indignities suffered by this defendant on Mr. Palms, his brother, and the members of that community. Mr. Hirschorn stated, and I agree, that mitigating factor 7 should be applied. The defendant clearly has no prior criminal record. However, he also asks this court to apply mitigating factor 8, that his conduct was the result of circumstances unlikely to reoccur. Mitigating factor 8 applies where a defendant accepts responsibility and shows a willingness to remove him or herself from the circumstances that may lead to similar unlawful conduct. And I would point to the court to State v. Rice at 425 and J. Super at 375, Appellate Division 2012. The forfeiture of his public employment has been imposed upon him as a statutory consequence of his criminal behavior, also citing to Rice. Furthermore, the defendant has continued to deny responsibility for what he has been convicted of having done. He may no longer be a police officer, but his refusal to accept the jury's verdict and his repeated efforts to shift the focus from the actual crime that was committed and the actual victims of this crime to his own personal hardships, which certainly undeniably are there, highlights his lack of remorse. He doesn't believe he did anything wrong, and his denial of culpability and blatant continued lack of remorse do not support the finding that the circumstances that occurred here are unlikely to recur. He has no appreciation for what he did that night. Defendant asks this court to consider his character and attitude as a reflection that he's unlikely to commit another offense under mitigating factor 9. As I just stated, he has failed to appreciate his own culpability and the impact that it's had on others. Even as is evident from the fact that his submission to the court indicates, and counsel indicated, he's willing to pay the victim back money that he was convicted of taking. There's repeated testimony in the trial transcripts that $600 was taken from the victim. The jury found that the amount taken was $500 or less. The defendant has never stated how much he would be willing to pay back the defendant. Why? Because he doesn't acknowledge that he did anything wrong. His utter lack of remorse and regret places him at risk of committing any number of theft offenses in the future. I ask the state to deny the application of mitigating factor 9 and apply aggravating factor 3, the risk of reoffense, for the reasons I just stated. I also would ask this court to reject the application of mitigating factor 10. Factor 10 is inapplicable when the conviction carries a presumption of imprisonment without a finding of serious injustice. And again, I reiterate and highlight that nothing that's been offered to this court in the record satisfies the serious injustice standard. He argues that factor 10 should be applied because he's appeared for court dates and has not been admonished by this court. However, he was required to come to court. Every defendant who gets a notice to appear in court is required to comply with the notice. Additionally, I would disagree with counsel in his papers. There is no nexus or any way to predict a probationer's success based on whether or not he or she shows up to court at their court dates prior to sentencing. Further, his completion of the police academy and his short employment as a Jersey City police officer, I would submit, don't actually help to show that he can follow instructions that would be given to him as part of non-custodial probation. Certainly at the police academy and as a sworn law enforcement officer, he received instructions about respecting his authority as a law enforcement officer, including how to conduct constitutionally lawful motor vehicle stops, searches, and seizures. He was given instructions about police department regulations requiring that all patrol stops of anybody, civilians or otherwise, be reported over the air and into logbooks. None of that was done here, as the evidence showed. The more obvious instruction he must have received in the police academy and while briefly employed as a police officer, yet clearly chose to ignore, was that a police officer should refrain from harassing, intimidating, victimizing, or violating the constitutional rights of members of the community that he is sworn to serve. He also seeks application of mitigating factor 11, that imprisonment will result in excessive hardship for himself or his dependents. And again, Mr. Hirschorn did point out, as I stated in my papers, he has a co-owner. There is nothing, no proof offered that without Mr. Suitt's presence at Winging It, that the establishment will go under. There is another co-owner who is also responsible for that business. So other than that assumption, nothing else has been offered by way of hardship. He has no dependents, and the hardship that he has cited to this court is not recognized as a hardship by the legislature. I would ask the court to give that mitigating factor no weight. The state seeks the application of aggravating factor 9, as I indicated earlier. Again, certainly we agree that it exists in every case, and I stress to the court that it needs to be given or considered to be given great weight in this case. This man was just shy of his 27th birthday when he committed the offenses, which he now stands before this court waiting to be sentenced. He had been a member of the Jersey City Police Department for approximately 3 years, and he doesn't share any of the characteristics that the court found in Jarvis or state VER. The only 2 cases in this state where there has been an upheld waiver of the mandatory minimum. The defendant is here for this court as an adult male because he made unprofessional and unjustifiable choices to engage in crimes while acting as a police officer. His current predicament is self-imposed and doesn't outweigh the need for general deterrence nor specific deterrence. There's great need in a case like this for general deterrence. Other law enforcement officials should not be given the message that committing a crime which touches upon their office, when caught, when convicted, will receive a probationary sentence despite a trial and despite a jury verdict given by members of the community. If that were to happen, this court would be sending a message to the public that police officers who come before the court are treated differently than any other civilian defendant who comes here to stand to be sentenced. I respectfully ask that this court sentence Denzel Suitt in accordance with the sentencing laws that require incarceration. The state is asking that this court consider imposing a term of 4 years with 2 years parole and eligibility on the crimes for which he's been convicted.
Your Honor, I want to thank you for this opportunity to speak to you. As was stated earlier by my attorney in the state, I did grow up in foster care. I've never met my mother. I met my father one time at the age of 23. The state, it's important for me to let you know about me because I think that this entire ordeal has happened and I've never had the opportunity to speak to really anybody and let anyone know who I am or why I became a police officer. At the age of 5 years old, I was in a foster home where I was handcuffed to other children. We were put in bed, and if anybody urinated, we would be beaten with extension cords. At the age of 7, I was in another foster home where the woman would get drunk and beat on us. At the age of 10, I was here in Jersey City at a place called Alpha House, which was on Pacific Avenue, shut down now. At Alpha House, I was tied up, naked, thrown into a tub, and had hot water thrown on me repeatedly. I also had other things that I won't get into that caused me to be hospitalized. Abuses that I faced in my time in Alpha House. As an adult, I was homeless. I struggled to get through school to become a police officer. The reason I did it is because all the things that I went through as a child, I reported those things. I've never been in court. None of those people were ever prosecuted. I've never had spoken to a police officer, a lawyer, a prosecutor, a judge, none of it. All of it was just done away because the state just doesn't want to take responsibility for the things that happen. I've had other cases where I've seen things happen to other kids and nothing happens. The reason I became a cop, I kept in touch with a lot of these programs that I was in order to let those children know that they have an outlet. In case something ever happens, they can report it to me. I mentor foster kids, I still do. I speak to children in school about police misconduct. I believe one of the letters that was submitted was given by a teacher who, I work with in that area. Even after my sentencing, or after my trial, I still speak to them about these things, police misconduct, and things that go on. One thing I think the state is really missing in their argument is the fact that I am a member of the community. I live in the community that I serve. Still, I lived there while I was serving there. I never moved out. I live across the street from Selah Court. I lived there. I established a business there. I served there. We give back. All my employees are members of the community as well. And it's not like I'm just this person who was there. I took this job and just left. I wanted to build up my community and make something of myself and show others that they can do the same. And as my attorney has stated, I've always maintained my innocence. I don't think I should be penalized because of that. That is my right, as she has stated. So I don't think I should be penalized because I maintain my innocence after a verdict. I obviously have to respect the jury's decision, the court's decision, and also I would like to point out that the community itself, there are community leaders who know me, who stand by me now, and they support me in this endeavor here. I just hope that, Your Honor takes this into consideration because I'm not trying to run from this. I'm not ever going to run from this. I've been through worse. No matter what they think, I am, or what she tries to say, I am a black man in America here. And I know that some people do face injustice, but that's not me. That's not my character, Your Honor. And I just want to thank you for the opportunity to talk to you.
Thank you.
Defense makes application pursuant to NJSA 2C 43-6.5C2. Argues that there is clear and convincing evidence that extraordinary circumstances exist such that the imposition of a mandatory minimum term would be a serious injustice that overrides the need to deter such conduct. Court is given a residuum of power that it may waive or reduce the mandatory minimum term of imprisonment required by the statute. The court is required to state with specificity its reasons if it so decides to waive or reduce the mandatory minimum. The statute, official misconduct here, is a bit of an anomaly. It is a third-degree crime that he stands convicted of, which carries with it, normally, presumption of non-incarceration for a first offender. The Supreme Court has tackled the issue addressing the injustice. This case has given me the opportunity to do a lot of reading in this area, which I thought I had done throughout my legal career. Always felt that jar bath was the standard. It's an idiosyncratic defendant. Court in jar bath cited by Evers, 175 New Jersey 355. Court said in Jarbath, we observed quotations, for example, that one group within the class of cases where the standard might be met includes those instances where the character and condition of the defendant are so idiosyncratic that incarceration or extended imprisonment for the purpose of general deterrence is not warranted. Now, of course, Jarbath was a presumption of imprisonment case, which I guess when one looks at it, is what we're dealing with here as well. Even though a third-degree crime would have the presumption of non-imprisonment, the statute mandating period of parole and eligibility flips the third degree on its head, makes it a presumption case. As the Evers Court found, we have consistently held that this residuum of power may be legitimately exercised in those truly extraordinary and unanticipated cases where the human cost of punishing a particular defendant to deter others from committing his offense would be too great. There is no doubt in this court's mind what Mr. Suitt went through growing up. The fact that he quite honestly accomplished what he did, becoming a police officer, graduating college, opening a business, is probably nothing short of a miracle. Because I would suspect if he showed his childhood history to anybody in the business we're in, that would never be the predicted outcome. I'm not here to address or question the verdict in this case. I've had the opportunity to do that. I've ruled on it. There was sufficient evidence to sustain the conviction as I ruled. What happened to Mr. Palms here that night was simply terrible. His treatment in attempting to report the misconduct of a police officer was atrocious. And it should never have gone that way. He was sent out of precincts. Officers wouldn't listen to him. And that is a significant problem. It's not what Mr. Suitt is being sentenced for today, though. He's being sentenced for taking the man's money. And I think we have to all keep that in mind. What was done to Mr. Palms and the way he was treated after the crime was committed was atrocious, and it should be looked into. Even though Mr. Suitt, by his conduct, set that in motion, he's not to be sentenced for it, and I want the record to be clear. Evers said our case law has amply described those instances that do not meet the serious injustice standard. However, our jurisprudence has not given trial courts guideposts for determining the extraordinary or extremely unusual case where the human cost of imprisoning a defendant for the sake of deterrence constitutes a serious injustice. It's a case-by-case analysis. There's no way we could expect our appellate courts to address every possible scenario in determining what is a serious injustice. And as was referenced before, Mr. Suitt was not a public official, was not a police officer. probably would have gotten PTI. Probably wouldn't even have a conviction, let alone looking to go to state prison for a minimum of 2 years. In reviewing the aggravating and mitigating factors, I do find aggravating factor 9 applies. There is a need to deter both specific and general deterrence. On the mitigating side, I do find that the defendant would compensate the victim in this matter. This is a property crime first and then an official misconduct. He runs and owns a business. There's not a large sum of money. He clearly has the financial wherewithal to pay that back. Mitigating factor 7 applies. He doesn't have any criminal history. Which, going back again to what Mr. Suitt spoke to and what everyone acknowledges is his upbringing, is probably remarkable in and of itself. Courts are to look at post-offense conduct. It's a little more than 3 years ago that this offense, I believe it was 2018, occurred. Mr. Suitt has not been re-involved. Has continued to operate a business through a pandemic. Continues to speak to children in the foster care system. When you look at the letters, and these are recent letters, speak about the man that stands before me today, clearly references a common theme of his upbringing, and did his upbringing lead him to be where he is today? I can't say it did, I can't say it didn't. It's certainly part of the mettle of the person that stands in front of me, without a doubt. The letters are quite moving, honestly. All of the letters, though, point to a common theme that Mr. Suitt is a man that continues to tries to do better by others. It's difficult for the court to reconcile the events of the night of the incident with these letters. But I've often told defendants when I sentenced them that you can't let one moment or one incident define you. The letters from those that know Mr. Suitt certainly don't define him as a thief or a corrupt police officer. If you look at the charges he's been convicted of, one would say that's what he is. But that's what he's been convicted of. Doesn't necessarily mean that's who he is. I think his character and attitude is such that it's unlikely he would commit future crimes. And so I do find 9 applies. Therefore, I don't find 3 on the aggravating factors apply. I don't find mitigating factor 11 applies. I haven't been provided with sufficient information to make that a finding. The real question then comes down to, is the human cost of punishing Mr. Suitt too great? Is the deterrence that would be achieved by taking him from the community and putting him in prison for a minimum of 2 years too great for the person that stands before the court? Probably one of the more difficult cases I've had the occasion to impose sentence on. And if I didn't say that, I wouldn't say that if it isn't true. The criminal justice system is based on punishment, as all of our old cases define it as. Although as I sit here over almost 9 years now, don't know that that isn't changing. We have a drug court in place for almost 20 years now to deal with rehabilitation. Less than 60 days ago, the Attorney General of this state entered a directive waiving mandatory minimum for all non-violent drug offenses, because simply locking people up for a minimum period of time served no purpose. There's talk of mental health courts being created in vicinages throughout the state because locking people up with mental health history is inappropriate. Well, if our goal is simply to punish, it's difficult to reconcile those three, and those are just three small examples of what our system of criminal justice really is. System of criminal justice and the job I swore to uphold was to be one of fairness. Temper punishment with compassion. Recognize faults that individuals hold and carry with them. Recognize there are victims, like Mr. Palms, who suffered unnecessary indignity that night for no reason of his own. But is putting Mr. Suitt in prison too great a cost? I think it is in this case. I think Mr. Suitt would respond to probationary treatment. I find, for all the reasons, including his upbringing, his letters, what I find the mitigating factors to substantially outweigh the aggravating factors, that the imposition of a mandatory minimum would be unduly harsh. It does not in any way indicate that this court believes that the verdict was not appropriate. I believe the evidence, the conviction was appropriate. But it is what I believe, or is, this case is one of those extraordinary and unanticipated cases where the interest of justice would not be served by putting Mr. Suitt in custody. Therefore, Suitt sentenced to 5 years probation, pay restitution in the amount of $500 to Mr. Palms. He's to serve 200 hours of community service. pay a $50 VCCB penalty, $75 Safe Neighborhood, $30 Law Enforcement Equipment and Training Fund, submit a DNA sample. Receives 1-day jail credit. Has 45 days to appeal. For good cause shown, and get a 30-day extension. 5 years to file a petition for post-conviction relief. I will stay the imposition of the sentence for 10 days, give the state the opportunity to review and determine what action they want to take. Based on that, I will address the commencement of any probationary period after I hear back from the state. So he won't be required to start probation. The state will have the opportunity to make a decision what they want to do as to sentence. I don't know what the defense is going to do as to the conviction. It may all be moot because there may be an appeal filed and a cross appeal anyway. But I'll hold everything for 10 days, give everybody the opportunity to address what you need to, and then I'll decide on the commencement of his probation.
Thank you, Judge.
Thank you, Judge.